immediately remove Black Fed Governor Lisa Cook. This comes after an appeals court rejected moving forward with the termination. Cook says she will not be stepping down. And Raja Jackson, son of UFC legend Rampage Jackson, has been arrested for felony assault after attacking wrestler Psycho Stu at a Los Angeles show. Rampage says his son needs anger management and community service. Get BIN News Now on demand 24/7 on the iHeartRadio app.
The following is a paid program and does not necessarily express the views or opinions of Equity Media, its management, staff, or affiliates of WBOK.
Now, it's the Monitor's Mic with your host, Stella Cement.
Welcome to the Monitor's Mic, where we talk oversight, policing, and you. I'm Stella Cement, your host and the Independent Police Monitor for the City of New Orleans, and with me is Chriselle Williams, our Deputy Police Monitor. We, your hosts, are not police officers, but we are experienced attorneys from the criminal legal field dedicated to transparency and accountability. This show is your go-to source for discussing policing, law enforcement oversight, and how it all impacts you. From the Office of the Independent Police Monitor, we offer independent perspectives on city government. The Office of the Independent Police Monitor, OIPM, serves as a crucial civilian oversight body for the New Orleans Police Department, the NOPD. We ensure transparency and accountability within the police department by making sure that NOPD follows their policies, abides by the consent decree and the sustainment strategy, and is compliant with all local, state, and federal laws. Our office operates independently from the NOPD and from the federal monitors. What do we do day to day? We take complaints of officer misconduct from the public and from police officers. We review misconduct investigations conducted by the NOPD's Internal Affairs, which is called the Public Integrity Bureau. We're on call 24 hours a day, every day of the year for officer-involved shootings and critical incidents, and we will go to the scene and monitor the force investigation from start to finish. We're advisory members of the Use of Force Review Board and the disciplinary hearings, and we run the Community Police Mediation Program. We engage the community to ensure your voice, opinions, and concerns are heard. This summer, the OIPM launched the 24-hour hotline for complaints of officer misconduct or accounts of positive policing. It's operational every day of the year. The hotline is available in English, Spanish, and Vietnamese. No matter how you reach the hotline, you always have the option to file completely anonymously through that platform, and you will be given a unique tracking number. You can reach the hotline through calling or texting 1-877-225-6476, which is OIPM. For our show today, we encourage you to call in with your questions, comments, and concerns. You can reach us on air at 504-582-9422. While we may not be able to address individual cases with you, we will commit to following up. So with that, let's learn more about today's guest. Chriselle?
Today, we're honored to welcome the Honorable Simone A. Levine. She has served as judge of Orleans Parish Criminal District Court, Section A, since May 2023. Her court has received praise for its trauma-informed and community-focused approach. Judge Levine has built a career around public accountability and fairness. She's worked as a homicide prosecutor, public corruption prosecutor, a public defender, and private defense attorney. As director of Court Watch NOLA, she exposed ethical issues in ankle monitoring industry and the misuse of DA subpoenas. From 2011 to 2016, she served as Deputy Police Monitor for the New Orleans Independent Police Monitor's Office. She oversaw use of force cases and disciplinary hearings and helped create the Police Complaint Mediation Program. Judge Levine has spoken in dozens of cities around the country. She's received awards from NACOL, New Orleans City Business, Tulane University, and Avada. She also taught law at Loyola University and criminal constitutional rights at John Jay College of Criminal Justice. So thank you so much for being with us today, Judge Levine.
So honored to be here, Trishelle and Miss Stella. Honored and humbled.
Oh,
Thank you for coming on the show. This is exciting for us to talk to you
Mhm.
because you're both a judge, but you are kind of in some ways a graduate of the Office of the Independent Police
Absolutely.
Monitor.
Always a member of our larger community. I will not forget that. That is for sure.
So, Judge Levine, you've been running Section A since 2023, and it's a courtroom at Orleans Parish Criminal District Court. But for people who are unfamiliar with the court system, can you describe what happens in criminal district court?
Sure. So, Criminal District Court here in New Orleans, otherwise known as Tulane and Broad,
Mhm.
we have two types of courtrooms. We have a courtroom which is in magistrate court, and that is where bail and bond is set initially, and there is a determination on whether those cases there's enough evidence to establish, at least at that preliminary showing, whether there is a felony or not. And then afterwards, once that showing is made, either through the grand jury or through a piece of paper that is called a bill of indictment or a bill of information, then it's brought to the other courtrooms, A through L. And A through L, mine being Section A, what happens is we have different parts of a proceeding. So we have discovery, we have suppression motions, we have rules to show cause, we have plea bargains, and then we have trials. And Trishelle, I do not want to use all of our time up because I'm also former director of Court Watch NOLA, and I love to explain the court system, and I will take up the whole hour and explain to you all the different proceedings in criminal court.
So, can you decide who's arrested?
So I certainly can't decide who is arrested. I have no say in that process. So specifically, a judge can sign a warrant. However, it does not go to the judges who are in sections A through L, which is one of the sections that I'm in. That is really exclusively reserved for either commissioners or the magistrate. The magistrate is elected by the people of New Orleans, that is Magistrate Lombard, or the commissioners, which are appointed by the judges, of which we have 4. And so they are approached to sign arrest warrants. We are not. Technically, we can be asked, but we are never really asked. And certainly I've never been asked. I've never been asked to sign an arrest warrant.
Well, can you decide who gets prosecuted?
I also cannot decide who can be prosecuted. And it is also important to know that now there are 2 agencies in state court that are prosecuting. There is the DA's office, which is DA Jason Williams, and then also there is the Attorney General's office. And the Attorney General's office decides to prosecute cases largely relating to troopers, state troopers that make the arrest. There's some exceptions to that rule. So, for example, if DA Jason Williams has a conflict, then the Attorney General's office will also step in and prosecute. But certainly that is above my pay grade on who it's determined can prosecute the case and who's prosecuted.
Well, what about trials? I mean, can you decide who actually goes to trial then?
Yeah, so this is a little bit more of a controversial point because so certainly I don't decide who goes to trial or not, but one thing that I do have discretion over is when they decide to go to trial. And so I say it's controversial because there's always a question of whether state will ask for a continuance, that means a delay of the trial, or if defense will ask for a delay in the trial and whether we would actually grant that trial. Defense counsel can always make a motion, which is called a motion to quash, and then the judge can always grant it, but it's very rare. If the judge grants the motion to quash, the prosecution can try to bring back the case, but that oftentimes that case does not go to trial.
Okay. So, Judge Levine, can you just explain to our listeners that may not know, what are the responsibilities of being a judge in criminal district court?
So there are many. One of the things that we really try to maintain is we try to maintain that neutral balance. I'm just going to talk about judges in general, right? Between knowing that there are victims on one side of many different crimes, and then that there are the constitutional rights of a defendant, which are the other side. There is one judge that has termed it the tightrope that a judge walks on to ensure that defendants are always provided that level of constitutional rights, that they have their due process, and then whether victims are afforded their voice, whether there is a level of accountability, and whether we do have a court system that ensures that public safety is really respected. It's a very tightrope to walk on a regular basis, but that's really what our responsibility is. We have responsibility to have an efficient docket, so to grant justice in an efficient manner, but qualitatively also in an ethical manner, and also in a way, in my section, I certainly underline in a respectful way toward all parties.
Okay. So let's talk about some of the things that are happening currently in Section A. First, you decided to keep Zoom meetings or Zoom court hearings open to the public even after COVID ended. So why is that something that you decided to do in your courtroom?
So I had somebody approach me recently and tell me, Judge, the reason why we trust you is because you came to the bench from a movement. And I said, what is that movement? Because these days, sometimes movements have a bad name. And the movement that I was told by this member of our community that I came from, which I very much agree, is the movement for transparent and fair courts. I still very much believe that this is essential. And so when I came to the bench, I had previously promised I would always keep my Zoom on, because if you have an incident that occurs in your community, you may be concerned to come to court. It may be a big deal for you to come to court, but you may still want to hear what is going on with the proceeding. You still may want to be involved. I still feel that it is incredibly important that communities stay involved in our criminal courts. And if it is an issue or an alleged crime that has involved a community member, I want to make sure that, that level of access is allowed. Additionally, sometimes victims cannot come in and testify in person. Sometimes defendants cannot make it in person. And so then I have the ability to allow somebody to appear by Zoom. It is important to note that I do not allow the pictures of witnesses and victims to be on Zoom. And I also do not mention the names of victims or witnesses in any proceeding before we hit the point of trial, because I know in New Orleans we have issues of witnesses feeling that they have fear in coming forward. So I always want to make sure to take that into account.
So that's kind of what you're discussing, is kind of how you have your courtroom as a community-focused approach, right?
That's right. One of the things, yeah. Mm-hmm.
So when we're introducing you, we also talked about how your courtroom received praise for the trauma-informed approach as well. So you talk a lot about trauma-informed justice. So can you explain exactly what that is?
It's a really essential point, and I have done a number of presentations, sometimes alone, sometimes with Judge Amanda Calagero from Family Court in Jefferson Parish, about what trauma-informed means. And trauma-informed means simply that you take into account that everyone that is in front of you, whether they are victims, whether they are alleged victims, whether they are defendants, oftentimes have had that trauma hard baked into them. There is something called a window of tolerance. And the window of tolerance oftentimes is much smaller when somebody has been traumatized. And in New Orleans, we have had so much trauma and so few services that have really been provided to any of us. And so the window of tolerance closes when you have seen your loved ones be hurt by your other loved ones, when you have witnessed or viewed shootings yourself on the street, when you have had your loved ones be incarcerated before, when you have seen your loved ones be victimized before, when you've been traumatized by gun violence and you walk into court and you see that somebody has, a gun before you even walk into court, when you see law enforcement, you may be traumatized by law enforcement themselves. All of that closes the window of tolerance. If you can't get a bus and you're late to court, if you are scared to bring your children into court, which in Section A, we always allow children in our section because we know that that is an impediment to people even appearing. All of that closes that window of tolerance. And to be aware that everyone has that level of trauma before they even get into court, it's integral. And so what happens with the trauma-informed court, and we had a special done on us on WDSU about this, is that it's essential to have a trauma-informed court that also walks along with procedural fairness. And I know at the police monitor's office, you're very aware of what procedural fairness is, but procedural fairness is you provide that level of respect to people on a regular basis, because oftentimes they will not get the level of respect that they need by many of their interactions in community, and certainly by the criminal courts before they even get into your court. And something as simple as, Mr. Roberts, how are you? Good morning, Mr. Roberts. I'm sorry I am late. I'm sorry that this case has taken longer than you want. Mr. Roberts, I'm happy to hear you now. It just gives the individual, whether it is a victim or a defendant, the feeling and the understanding that the court is hearing them, when oftentimes the legal system hears nobody. And then that individual will feel, because they've been heard, that they, in fact, themselves afterwards will respect the rule of law that much more. And so that's the concept.
I love that approach.
I do too.
I think it's maybe something I heard from the police monitor's office earlier.
I love that approach. I'm now going to play devil's advocate
Okay.
for the people that are saying, well, isn't the statue of justice blind? Aren't we supposed to not really be seeing people, but be thinking about the laws? Isn't this taking the focus away from what you're there to do, which is not to worry about people's kids necessarily, not to worry about bus routes and bus schedules, but to make sure that the law is followed? And isn't that black and white? You either broke it or you didn't. What would you say to somebody who's kind of rejecting a lot of the principles that you're building Section A on?
So I would say that we can absolutely do both. And I have treated people with a huge amount of dignity and also sentenced them to a large amount of jail time at the very same time. And I have seen individuals that understand that there has to be a level of accountability on their part as a result of the court consistently treating them with respect. There's absolutely no reason why we cannot treat people with respect and also ensure that all of the laws are followed, and also all of the laws are followed blindly, as you had mentioned, and that justice is in fact blind. What justice, when you have the issue of whether justice is blind, that relates to impartial courts.
Talk to us about that. What does that mean?
That's absolutely essential. So I have had the great luck of having experience as both a criminal defense attorney as well as a prosecutor. And so I have had experience as a public defender for 6 years, and as a private defense attorney for 2. I have had experience as a prosecutor for approximately 2 years. So I have it from both sides. I was the monitor of our criminal courts as director of Court Watch NOLA. I was the monitor of our police department, as you know, as the deputy police monitor in Trichelle's spot. And what an impartial court means, in my opinion, it means many different things, but it does not matter who it is that is prosecuting the case. it does not matter who is defending the case, that every single case is different, and that you look at the facts of every single case and you have that new review, that the facts, that the circumstances, that the individual victims, and that the individual defendants are completely different entities, and that it doesn't matter who it is that's prosecuting, your previous relationship with the person that's prosecuting the case. It doesn't matter who is defending, your previous relationship with the person that's defending. This is essential, because what you have is you have so many people that come to Tulane and Broad and say, oh, the judge is friends with X, Y, and Z. There's no way that we're
Right.
going to have a fair shake out of this system. And people, unfortunately, our court has had that reputation after decades on decades on decades of people really saying that. And so it's really time to break that cycle. And I have broken that cycle in Section A. I continuously am told all of the time, we have no idea how you're going to rule, judge, until you do. And that's essential, because you need to walk into a court knowing that you are going to get a fair shake.
So I want to return to a couple things that you just brought up that I thought are great points, but I see we have actually two callers. So first I'm going to put on Miss Alicia. You are on the air with the Monitor's Mic. Thank you for waiting, and thank you for your call.
Hello, Monitor's Mike, and to Judge Levine.
So nice to hear from you, Miss Plummer.
You do a great job on the bench. I've sat in your court, and you don't know which way you're going, but what I do have to say about you is you are very respectful to both sides of the situation. I was in voir dire one time, and I was waiting, how they questions and stuff, and it was Judge Shea Court, but Judge Shea was just so mean to the defense attorney. So every time they came back to us and said, would you vote such a way because of this and other, will we present? I said, I'll vote not guilty. I said, because I don't like how the judge is treating the defendant's attorney. And after 3 times, Judge Shea threw me out, sent me back to the jury room. But you're doing a great job. And I like the respect that you give to everybody that comes into your courtroom. Keep up the good job.
Oh, thank you so much, Miss Plummer. That means a lot. So I've been knowing Miss Plummer for a very long time, but Miss Plummer also, just like the court, walks into everything in a new way, in a very objective way, taking circumstances into account. So I appreciate that.
And I appreciate that call. Thank you so much. And I want to go back to some of the points that you just made, particularly around the idea of looking at each case anew. Again, if we were to push back against that, what about people that would say,
do it, Stella.
What about our listeners who would say, but how do we identify systemic failure? How do we identify systemic injustices in our courtroom if we're always wiping the slate clean each day that we start a new case? We hear about epidemics. There's a crime epidemic. There's an opioid epidemic. There's this type of epidemic, that type of epidemic. How can we identify these patterns or these signs potentially of things like racist prosecution or concerning favors maybe that are being worked out in the side of the defense bar? I'm trying to bring up unethical behavior that might be seen on either side. If we are just wiping the slate clean case to case.
So I do not think that wiping the slate clean allows us to forget about any of the patterns. I think it is essential to take all of the previous patterns into consideration. I do know our long history with wrongful incarceration and conviction in this town. And honestly, this new trend of making sure that we are efficient at all levels, I think absolutely needs to have the hindsight of 2020 be taken into consideration, because if you talk to the Innocence Project will tell you that, and in fact, Emily Ma, formerly of the DA's office, will tell you that one of the reasons why we have such a high wrongful conviction rate is because we've had judges that have felt the pressure of flying through proceedings and making it a case of efficiency and not ensuring that discovery, that that a proper and a fair trial is actually provided to the individual. So we absolutely need to take patterns into consideration. But I'm going to play devil's advocate for your devil's advocate.
Yes, let's do it. Let's turn the table again.
And say that I think that one of the conspiracies that occur not just at Tulane and Broad traditionally, but also in most criminal courts across the country is that we have proceedings that are not human being centered. And that where you don't have proceedings that are human being centered, what you have is you have a system and you have a machine that rolls over people. And I refuse to be a judge that rolls over people. There are many cases that come to Tulane and Broad. There are many different people's rights that need to be taken into perspective. For example, in Section A, we have a victim room, specifically a room where victims are able to be alone. They do not have to be in front of the defendant's family, the accused family. They don't have to be in front of the accused. They can testify from that room. It is a room that closes. It is a room that has protection if they don't want to interact with the public at large, because what we know is we know that there is a level of fear and terror sometimes from that alleged victims feel. And so if we don't take that into perspective, guess what? We're not going to have victims that come to criminal court. We're not going to have witnesses that come to criminal court. If I don't take into perspective that someone who is accused has kids, that they do not have the money to have somebody watch over, they don't have the family members that watch over, those people are not going to come to court. There was a report done right here in Orleans Parish from the MacArthur Justice Institute that found that one of the major obstacles for defendants returning back to court is that they did not have child care. And so one of our pet projects in Section A that we're trying to begin is to start a program where victims, witnesses, and defendants will have the ability to have free child care when they are required to be in criminal court, and that those children will receive trauma care if the caregivers want them to receive trauma care, because what we know is that secondary trauma from defendants, from victims, from witnesses, if it is not addressed, will then be shed upon their children, and those will be the new individuals that are here in criminal district court at Tulane and Broad. And so it's an intervention to actually stop that process.
And again, I have a question on that, but I see we have another caller. I'm so excited. Hi, Ronald. You're on the air
Hello.
with Monitors Mike.
Well, I am so glad to hear that. I do know in Section 8, I have an opportunity to watch a lot of the coordinating proceedings. But in Section 8, everything, there's no sidebars, no backdoor deals. What's in front of you on the front table is right there. And the judge is very methodically explaining to the audience. I've said in the court a couple of times, well, for the record, I'm not related to the judge. I'm not a campaign manager. I'm not paid.
Thank you for
I'm
clarifying
telling what
that.
I witnessed.
Ronald.
All right. So we, as a person, I'm not a community activist, but I work in the community. And one of the things happened, we always had issues with the legal system. But when you go to Section 8, you can ask the question, the laws apply that you can understand as a layperson. You understand, and I appreciate the judge taking that approach to it. It's the people court, and some of the law stuff, folks don't know what's going on. So I appreciate that, and it's starting to happen in some of the other courts I've seen. Is less sidebars. I'm not saying all the courts, but it's not as many sidebars as you used to have, where the lawyers go over there and come back and they read off something in the mic, and you wind up with 20 years. And you don't even know why you're going to jail. So I do want to acknowledge the judge on air, and hopefully I'll see her real soon to tell her again, as I talk with as many times as I get an opportunity. She works hard. She's doing a great job. But the service to the people, that's the most important thing happens, to serve the people. And when you can go to court and understand what has happened to you with this piece that you're going through, I'm fine with it. And I also want to compliment on the patience. And not everybody, but some people deserve second chance. And the judge has been very instrumental in second chances. So again, I want to thank you, and I want to thank this program. Let's keep up the good work, because it's all about the people. And again, I'm not paid. And stuff is just, and I have several folks that could testify to the same thing in watching how the judge operate. And once again, we have good public service in the city of New Orleans on all levels. And I need to say that because I know we're at a critical time for a reelection, but we have good folks doing good work. And one of them I can say right now doing good work that reminds to keep the people at the forefront, Section 8 Judge Levine. So keep up the good work, and we're going to be praying for you. We're going to be here for you. Again, it's for the people. Thank you for taking my call, and I'll be listening.
Thank you so much for listening and for calling
All
in,
right.
Ronald.
Thank you.
All righty.
Mr. Ronald, I so appreciate all your comments. I did have something that I wanted to say relative to his comments. So, second chances.
Yeah, we wanted to ask you about that. You know,
Mhm.
there's this need to balance public safety with rehabilitation. Do you mind explaining to us how do you, as a judge, balance the need for public safety with that very real desire that you've described to see people as people and to believe in second chances and in rehabilitation?
So, I very much believe in rehabilitation. What I do not believe in is incarceration for the purpose of punishment. I do not think that that serves a purpose. I do believe in incarceration. I do believe that there is a role in our society for jails, but the reason why I believe there is a role in our society for jails is to ensure that people are safe as a containment. And there are some people that they are just not at the point where we can say that they will be safe with the rest and the larger part of our community. And that is essential. And I can understand that somebody has been traumatized. I can see all the different things that an individual may have gone through in their life to establish how very traumatized that person is. But I am dedicated also to ensuring the safety of New Orleanians, and I cannot release people that I do not believe should be released that, will not keep us safe. And so that, again, is that same tightrope between the two sides. And one thing that I am always trying to ensure is that mental health is a part of almost any sentence that I give. And I have a lecture, some might say, in my courtroom that occurs all the time where I require somebody to do mental health. Mental health therapy, trauma therapy, and I give them different resources that are free resources for them to do it. They have to come back to the court and show that they've actually gone through all of that mental health. And oftentimes there's this level of stigma when I require somebody to do that. And so the lecture that I give is I say, you see those prosecutors in back of you. They turn around, they look at the prosecutors. I say, you see these public defenders to your left. You see this private defense attorney here. You see this court staff here. You see this judge here. You see my law clerk. We all need mental health. All of us here in New Orleans. It is my strong belief that if we had those mental health resources for free after Katrina, we would see half of the level of violence cut here in New Orleans. We just did not have those mental health resources available to us for free, not like in other cities, not like in New York after 9/11, not like in North Carolina after the big storm that they faced. All of these resources were free to the larger community. We did not have it in New Orleans. And so that is really the essential part of rehabilitating or not, is getting people to understand, think through their actions, understand that a lot of their actions, whether it is retaliatory, whether it is abusing drugs or alcohol, that it is because of what they have gone through to really stop that level of pattern. And until you get people to think through that, you're not going to actually change anything in the system. And the key as a judge is to understand who has that capacity, the ability to stop that ever rolling ball, to stop that pattern, and who simply just does not. And it's the people that do not, that I have to keep incarcerated maybe down the road 10 or 20 or 30 years down the road, maybe they will get to that point, but I cannot allow them to actually put us in harm's way if I think that they can't get it the first time. And really, that's what the first time that they're in front of me, which oftentimes maybe the third or fourth time that they're in court, that is really the key role that a judge plays. And that's a new method. And there's a lot of people at Tulane and Broad who do not like new approaches. There are a lot of people at Tulane and Broad who say, I want the judge that is always going to agree with me because I know that they're pro-defense. Or I want the judge that I know is pro-prosecution that is always going to sentence somebody that way. And that is not the way this judge is. It is a new approach, but it is a best practice approach because as director of Court Watch NOLA, I was fortunate to study best practices for a long time to understand really how we need to move forward as a court.
So we're talking about public safety. We're talking about best approaches. I feel that I really want to shift us to considering public safety and best approaches when it comes to our police officers. And you have unique insight into our police department because you were a leader at the Office of the Independent Police Monitor for a very important time in our history. You started there in 2011?
Yes.
Which was really the beginning of the Office of the Independent Police Monitor in a lot of respects because it started in 2008. Susan was appointed in 2009. So, and for anyone who's unfamiliar, I'm being very casual now. Susan Hudson, who is our sheriff. And you started shortly after Susan kind of got her footing in that office. And what was it like to work in police oversight then?
Yeah, I would definitely say that I did not start when the office started. There was so much work that went into that office, so many people. And honestly, the beauty of the police monitor's office and also its longevity was how community came together to create this office. And that is essential because in New Orleans, nothing is lasting unless you have the full support of community to create these institutions and you ensure that there is something in place that these institutions are not allowed to disappear on us, which certainly was what occurred with the police monitor's office. So I cannot take credit for being there in the beginning. There are so many other people that created that office. What I will tell you, which was very interesting in our time, and I don't know how it works now, is that we had created a number of new projects. One of them was monitoring police disciplinary hearings. And so we had talked a lot about internal retaliation at the time in the police department. So officers doing the right thing and calling out issues of, unethical practices in the police department and oftentimes finding themselves in administrative violations. And so what we did was we opened ourselves up to hearing about that. And then also what we did was we just looked at the four corners of the investigation and we would sit in all of these disciplinary hearings and we would give our approach and we would ask questions. The other thing that was started before I was there, but certainly I know has continued, is our ability to be involved in use of force cases. And that was revolutionary at the time. The fact that we were allowed inside the yellow tape when there is a shooting of a civilian and that we were then allowed to be present during the interrogation of police officers who were involved in that shooting of a civilian was just an enormous achievement as far as what oversight allows and the level of oversight, really, that the police department gave the police monitor's office in doing that. And so one of the things that we worked on when I was there at the police monitor's office was the case of Wendell Allen.
Yeah, can you tell us about that?
So Wendell Allen was the young African-American college student who was shot and killed by police during a joint task force. And one of the things that we did was we went back to the police department And I sat in on every single one of the interviews and investigations and interrogations of officers, which there were many, many, over 10. And one of the police officers in that shooting had said that he had had body-worn camera. And at the time, body-worn camera was not allowed.
Right.
And so it was an administrative violation for him to admit that, but he still admitted it. And then we
Powerful.
went on to the next interview of another police officer that was involved, and another police officer that was involved, and another police. And I said to the investigator who was doing the interviews, "Are you going to get that officer back who had the body worn camera? Are we?" And the officer said, "What body worn camera?" And so I had to go back and forth with that officer. And eventually we had to go to the head of the department. And the head of the department got that body worn camera back. And that officer ended up taking a plea to 4 years after having had the case go through the grand jury and then go to criminal court for the shooting of Wendell Allen. And so that was a case that the police monitor's office had been very much involved in, and really and also, frankly, when it came to the officer, there was a level of connection between the officer taking responsibility. This is way before Missouri. This is way before any of the larger movements. And really, it was the first time in the South where the officer had taken responsibility. It was a white officer, an African-American young man who was shot and killed. It was a level of accountability that police officer took in taking a plea as compared to, the victim and the victim's family coming together over that. We have just been through so much when it comes to this police department, and the way in which it has been trained now, the level of, just the amount of time that is invested in the training of each officer and the level of accountability in the police department. It is far from perfect, but we have certainly come a very far way compared to where we were in 2011.
So what I'm hearing from you right now, Judge Levine, is basically, you see a different NOPD now in your courtroom than you have experienced when you were doing police oversight?
Yes. And it's not to say that there are not bad apples, but absolutely, yes, very different police department than when I first began to monitor the police department in 2011.
And has your 5 years that you spent in police oversight, does that ever influence the way that you respond as a judge?
So it's a good question. So I am very sympathetic to what the officers' schedules are. I am always trying to get officers in and out of the court, knowing that we have officers that need to be out on the street and not waiting in court all day and all day long. That is always a priority for me. I give bottled water to every witness that testifies in my court, police officers included. And also, I am very careful to make sure to suppress evidence where, and I can't talk about individual cases, where I feel like there has been bad policing. And that is really the role of the judge. Again, you cannot be pro-prosecution. You cannot be pro-police. You cannot be pro-defense. You cannot be pro this one individual. You have to look at those individual cases. You have to really know what that procedure is, what somebody's constitutional rights are. When I taught over at Loyola Law and I taught over at John Jay, that's specifically what I taught, was what evidence needs to be suppressed or cannot be allowed at trial based on whether someone's constitutional rights have been violated. And, I think that that's just essential, or else our community will believe that their rights do not matter. And if community believes that their rights do not matter, they will not depend on the court system, and then they will take the law in their own hands. And that is exactly what we do not want to go back to. And that's the reason why a constitutional police department is utterly essential. And frankly, constitutional courts that recognize that are utterly essential.
I could not agree more. I mean, you hear us in the background going,
constitutional
doing
policing.
our, you're saying the magic words, constitutional
Yeah.
policing. We love to hear it. So we do get police officers who listen to our show. We love all of our listeners, and we love to hear whenever NOPD officers are listening. So if there is a police officer listening, what do you wish that police officer knew before walking into Section A, other than the fact that they will be treated with respect and given a bottle of water, which I have to say is not a small thing. That's a huge thing. That's a huge thing. But what else do you wish they knew before they walked into Section A?
They should absolutely know that Section A will treat them respectfully, that we will keep their schedule in mind, knowing that officers do have to get out on the street, but that they must show up.
Yeah. You have to abide by your warrants.
Yes, that
your
oftentimes
subpoenas.
we have, I won't say oftentimes, that we have issues with police officers appearing in criminal court. And, this relates to the efficiency of a court and whether we can have those suppression hearings on a regular basis. I think that that's essential. And also that Section A will hold them to the letter of the law. And also, by the way, treat those police officers respectfully while holding them to the letter of the law. There's really no reason why anyone needs to be treated disrespectfully and also hold them to the letter of the law, whether that is a police officer or whether that is a victim or a defendant. And the only other thing I will mention is that people at this point know that it is nursery school rules in Section A. Nursery school rules, as you know, since I am a proud mama and others in this room might be as well, means no yelling, no name calling, no interrupting, and no calling each other a liar. So, or any of the words that are mean liar, which usually is disingenuous. And you can attack a case. You can say that a case is bad. You can say facts are incorrect. You can say the facts are not correct, but you do not have to call the individual out. And once you take that issue of personal ego out of the equation, then you get to a more professional court. And so, that is certainly what we abide by in Section A. And oftentimes I have to remind people that that is the case.
Well, you're taking some of the theater out of the courtroom, and
people are still allowed to speak in an elevated voice to the jury.
And
I
to
certainly
be
allow
dramatic
for that.
and pound on tables, I hope.
Yes, pounding on tables
what is
is
justice
also okay.
if we don't get to pound on a couple tables?
What they're not allowed to do is yell and scream at each other when there is not a jury that is there in front, right? Because I can hear you just as well if you are speaking at a normal tone as compared to an elevated tone, and they are not allowed to, to really call each other's names. There's just really, or to interrupt, because my court reporter can't hear, I can't hear if you interrupt each other. And so that sometimes does happen with police officers, where you have an individual attorney who's asking questions and the officer is trying to respond. And oftentimes there's a level of interruption. And so I do have to make sure to maintain order, make sure that that doesn't happen.
Do you bring your trauma-informed approach to police officers? When you were saying, you bring it to victims, to witnesses, to defendants, do you also extend that approach to the police officers that walk into Section A?
I extend that to every individual in my courtroom. What I know is that I know that traditionally Tulane and Broad has not been a court where that has been taken into consideration. But it's really interesting relating to the trauma of officers. When I was in the police monitor's office, one of the things that we tried to start, we were not successful, is we tried to start a free therapeutic program for officers. And we had done some case studies beforehand, And this actually led to the police complaint mediation program, which we did start, which actually has been rather successful, I think.
Very successful.
Very.
So
We're constantly expanding on it.
which is
Yeah.
great.
Yeah.
But what we did was I went and I spoke to a number of officers, and it was just sort of anecdotal, but we wanted to understand where the trauma of officers came from. The reason why we wanted to understand where the trauma of police officers came from was because we knew that if we got free trauma care for police officers, that would lead to less police misconduct and less use of force cases if we actually had solved that trauma problem in police officers. And so that's the reason why we did that. And what we found, and this is not unique to police officers, let alone to NOPD, is we found that the main reason that police officers were traumatized was not because of the dead bodies they were walking over, not because of the level of violence that they saw, not because of really anything that they saw in the field, but really because their supervisor wasn't listening to them. Because they had a shift in the night watch, and now nobody had heard them because they had a partner that they were beefing with. That it was all of these things that involve the politics of how people get along. And that is really no different. I mean, sure, all of our listeners know this when they think about their own personal situation and what makes them miserable or happy at work is, are they getting along with their colleagues? Do they have a supervisor that is keeping all of this in mind? And it wasn't the dead bodies that people were walking over. And so that was very interesting. And so, yes, I do. And you know, honestly, the interactions between system players and what trauma that raises.
What I'm really hearing, a theme of this conversation, is this idea of health and viewing these spaces as almost ecosystems. Your courtroom is an ecosystem, and you want to make sure it's a healthy one, that everyone is interacting in a way that feels fair, understandable. We know what the rules are. There aren't secret rules or a secondary set of way of doing things. It's accessible, it's understandable, it's seeable, and it's feelable. Like we can feel it when we walk in. And when you say that police officer trauma comes from interactions that they're having within the agency, that's again this idea of the health of the organization is going to influence the health of the individual and the trauma of the individual and what they carry into their next set of interactions. I mean, I love to hear this type of system thinking.
And one of the things that we really pride ourselves in Section A, I have a fantastic team. I have a fantastic minute clerk, Tim Trosclair. I have a fantastic assistant, Laverne Thompson, fantastic court reporters, fantastic deputies in my court. What we understand is that we have to create a little space in that building, which has traditionally been a place of trauma, where people can rest and relax between cases. And we are very proud that we have public defenders that stay in our court and just stay there. They don't have any cases. They just need a quiet place to rest. We have prosecutors that do the same. We have law enforcement that does the same, although most of the time, as soon as they are released, they leave to get back on the street. And that we have sort of that quieter place where people can be in the meantime, because we do understand how incredibly hard this work is. We know how hard this is for people that are accused. We know how hard this is for victims. We want to be able to really offer that space.
I think that's wonderful. I see we're coming up on time. And I wanted to ask you, because I feel you've brought so much thoughtful information to this show. What do you wish we had asked you? Because I really feel, I was going to ask, you know, what do you want your legacy to be? Or what do you hope the public walks away from this conversation with? But I feel you've given us so much that I kind of want to ask, instead, I want to put the pressure on you. What do you feel we haven't asked?
You know, one of the things that I think is really that I bring, so every judge brings different things to the table. And, oftentimes I think judges feel that they have to turn their empathy off when they get to be a judge. They have to turn their background off when they get to be a judge. And one of the things that I really bring to playing that role as a judge is being the executive director of Court Watch NOLA. And Court Watch NOLA is a group that goes in, it trains volunteers, and I did this for 5 or 6 years now. It brings individuals into court and trains them beforehand on what court protocol is, what court procedure is. And we had hundreds and hundreds of volunteers when I was there going into court and collecting data and then afterwards putting that data in reports and making sure that the media was involved in showcasing that data. And the reason why that was important is because I feel that there is this trend recently. It's not to say that some judges should not be more efficient. Certainly, we've had a problem where we've had judges that have, because of health reasons, not been as efficient as they could with their docket. But that is not the only measure that we look at cases for. People are not a number. Victims are not a number. Accused individuals are not a number. That if we push cases forward and only believe that efficiency is the key, then what results is we push cases out to trial without allowing defense to have the discovery, all of the evidence that they need. We push cases out without the DNA being tested. We take pleas without victims taking their interests into consideration. In Section A, I will not take a plea without having the victim's interests in consideration. I ask it on every single case. But if efficiency was only my measure, then I would just get rid of cases left, right, and center without having all of the human values and human rights really being taken into consideration. And so years of being director of Court Watch NOLA has really taught me that we have to look at the quality of cases if we want to lower the level of wrongful incarceration here in New Orleans, which is essential. And it is my strong belief that here in New Orleans, we need new methods. We need new approaches. We cannot just have people that are running for office that represent one side or another, or are being promoted by one side or another, that the community at large loses out when that is the case. And that is not what fair and impartial judging is really about.
Great last words.
Yes.
Perfect. Thank you so much, Judge. We really appreciate it.
Well, that wraps up today's episode of The Monitor's Mic. I want to extend a heartfelt thank you to all our listeners for tuning in and staying engaged with the crucial conversations we're having about police oversight and community safety. Thank you again so much to Judge Levine for coming on to today's show on The Monitor's Mic. Before we close, I want to remind everyone about OIPM's 24/7 complaint hotline. It's operational every day of the year, and you can call or text 1-877-225-6476. That's 1-877-225-OIPM. The hotline is available in English, Spanish, and Vietnamese, and you can also file complaints through our website at www.nolaipm.gov in those same languages. No matter how you reach the hotline, you can always have an option to file completely anonymously through that platform. As always, if you missed any part of today's show, I want to catch up on past episodes, visit our website again at www.nolaipm.gov. And you can also follow us and find us on YouTube at NOLA IPM, on Instagram at NOLA OIPM, and Facebook at New Orleans Independent Police Monitor. And I do also want to remind the public that our shows are also on Spotify if you just look up The Monitor's Mic. And until next time, stay informed, stay involved, and stay committed to building a safer community. And this has been the Monitor's Mic.
Thank you.
Thank you so much, Judge.